Hey, I'm bankruptcy attorney Matt McCune. Welcome to the Bankruptcy Show, the show your creditors really don't want you to watch or listen to. We're going to break down the facts about debt and bankruptcy, showing you what your legal rights really are and giving you the information that you need to take care of yourself and your family. Let's get into today's episode. Hey, bankruptcy attorney Matt McCune here. Let's jump right into episode 2. Chapter 7 bankruptcy, by far the most common type of bankruptcy. Anytime you're looking to go bankrupt as a normal person, a consumer, Chapter 7 should be the first thing you look at. There's like 6 different types of bankruptcy within the code, but we can remove 4 of them pretty quickly. Don't worry about it. BK Fast Pass, this show is all about consumer bankruptcy, helping normal people move forward. So, your 2 choices are 7 and 13. Chapter 13 is going to be next episode. For this episode, let's talk about by far the most common type of bankruptcy, and that's Chapter 7. Why is it so common? Well, it's the easiest way to get in and out of the system. It's the fastest route to what's called a discharge. The whole damn reason people call me is when they're looking for debt relief is because through the bankruptcy system, you can get what's called a discharge. A discharge is a piece of paper signed by a federal bankruptcy judge that kind of magically says, poof, you don't owe a bunch of money anymore, and there are no tax consequences to those debts being discharged into bankruptcy. That's important as well. So you always look at Chapter 7 first when exploring your bankruptcy options. Now, you got to be careful. There's a lot of shithead attorneys, in my opinion, that'll kind of try to talk you out of a 7 even though you're eligible. And here's why. They're like, well, don't do that. I'll file a 0 down Chapter 13. That's the big scam, right? You can go bankrupt for 0, right? Well, alarm bells should be going off your head when you hear that. Basically what they do is they make it easy for you to get into a 13. And why do they do that? Because they make double in a Chapter 13 at a minimum, sometimes 3 times what they would make in a Chapter 7. It's total bullshit. I don't feel like the legal system, the courts have done a good enough job in pushing back against it. So let's be careful about that. There's a lot of fuckwad lawyers out there that'll put you into a 13 when you have no reason whatsoever to be in there other than them making a bunch of money. It's criminal, in my opinion. Rant over. So let's talk about 7. First and foremost, first question I want to ask is am I eligible to file a Chapter 7 bankruptcy, right? Well, there's income limitations. There's a couple things we need to talk about. So, look, you can't file a Chapter 7 if you filed a Chapter 7 in the last 8 years, right? You can only do a 7 every 8 years. So if you have a prior bankruptcy, if it's a Chapter 7, if it's been less than 8 years, you got to wait until you get past that 8-year point to file another 7. And then there are income limitations to being eligible as well. And it's a little bit gray. So you'll hear about this means test and this median family income, these sort of things. Basically, if your income is below the median income for the household size in your state, there's a presumption that you're eligible for Chapter 7. The idea is the government, in all their infinite wisdom, predetermine these numbers. And if you make more than it, they think you can afford to pay something back in a 13. If you make less than it, it's presumed that you can't, and that you should be able to file a 7. So no prior bankruptcy in the last 8 years, household income below median, which can be a little tricky to how to determine, which is why you need a good bankruptcy attorney to do that for you. That kind of bumps you into the category of like, okay, looks like I might be able to do a 7. Now, that doesn't mean you still want to do a Chapter 7. You got to be real careful. Look, the Chapter 7 bankruptcy trustee is the big bad wolf of the bankruptcy world. Look, I got a lot of friends that are Chapter 7 trustees. They're good people. They're not judges. They're private attorneys that basically have a contract with the Justice Department, a branch of the U.S. Trustee's Office, a branch of the Justice Department, to oversee the Chapter 7 case. At the end of the day, the Chapter 7 trustee's main job is to liquidate non-exempt assets. And this is an important thing to talk about. Most people that go bankrupt are what we call a no asset case. What that means is the minimal assets that I that I do have are either protected under the law or of such low amount that no one actually cares about them. So if you have non-exempt assets, well, that's when the Chapter 7 trustee can fuck your life up a little bit. And look, things get sold. The bankruptcy trustee has incredible power to get at your unprotected assets. Well, the logical question to have from there is, well, which assets are protected? That depends on which state you live in. Bankruptcy is incredibly complicated. Yet another reason to find a good attorney. So bankruptcy's federal court, right? Each bankruptcy court is kind of a branch of the federal district court for the state you live in, right? So in Colorado, we got one district court, District of Colorado. Bankruptcy court's a branch of that. But in California, when you have multiple federal courts, each federal district court is also going to have a bankruptcy court attached to it. So it is federal, but the states, the individual states, can choose to set their own exemption limits. So look, bankruptcy is this weird world combination of state and federal law that gets kind of confusing, understandably. But the main thing to understand is, as far as assets that will be protected, will depend on which state you live in. So, I can't tell you as a Colorado attorney, what your exemptions would be in New Jersey without looking it up, right? I don't know. I can tell you, I have everything memorized in Colorado. So you typically want to make sure you're getting a good attorney in your jurisdiction. It's very, very state specific because the rules are different. But the big picture stuff is pretty much universally your 401ks, that sort of retirement account is going to be protected. So you can have a bunch of money in your 401k, go bankrupt, nobody can touch it. Other retirement accounts, like in most states, Roth, IRAs, those sort of things are still protected. But California has some weird rules about that. Equity in your home, which is the main asset for people, if you're lucky enough to own a home, that can be protected up to certain limits. And it depends on which state. So in Colorado, we have really good exemptions for the homestead. You can have $250,000. If you're over 60, you can have $350,000 equity, go bankrupt, and no one can touch it. Most states don't have homestead exemptions that high. So again, this is super important. Never get into a Chapter 7 without being very, very clear about which assets might be at risk. Chapter 7 can be quicksand. Whereas if you file a Chapter 7, you might not be able to get out of it. And that's something to be very careful about. Whereas a Chapter 13, you get to Chapter 13, you don't like the way this goes or whatever, you have an absolute right to say, fuck it, never mind, I'm leaving. You do not have that right in Chapter 7. So it's super, super important that you're talking to someone that knows what the hell they're doing before you file a 7. But at the same time, if you're eligible and none of your assets are at risk, man, it makes a ton of sense. I always tell people, do you want to be in and out of bankruptcy in 3 to 4 months or 3 to 5 years, which is what you're looking at in a 13, and that's an easy question to answer. So 7s are tricky, but the first thing you should consider. Okay, we talked about who qualifies, what Chapter 7 does. Well, look, like any bankruptcy filing, it stops the harassment from your creditors. Something called an automatic stay takes effect when you file a bankruptcy. Chapter 7, the stay doesn't last long because the case doesn't last that long, but you wipe out a bunch of your debt. Here's the presumption. Assume a debt goes away in a bankruptcy. Okay? In Chapter 7, you assume a debt gets wiped out unless it falls into a certain bucket. And the big buckets are taxes, child support, and student loans. Right? So if you owe taxes for the last 3 years, those are called priority taxes. Those will survive a Chapter 7 bankruptcy. There's, even older taxes can survive if certain other things happen or there's a tax lien or something like that. Your child support obligations, your alimony, pay that shit. You should be paying that anyway. Never be looking to get rid of that stuff. It's not going to happen in the bankruptcy system. We call that a domestic support obligation in my world. And you're going to have to pay those things. As well you should, by the way. And then the student loans. Look, this is I'm going to do a whole show on student loans at some point. The presumption is that student loans do not go away in a bankruptcy. But if you can show you have what's called an undue hardship, you might actually be able to get rid of student loans in a Chapter 7 bankruptcy. The problem is you typically, like if they're federal, you have to sue the government. You have to file what's called an adversary proceeding in the bankruptcy court to get a determination that those loans were discharged, because the presumption is they're not. A lot of bankruptcy attorneys don't even do adversary proceedings. That's why, these are the hard questions you're going to want to ask, or make sure you're getting in touch with a good attorney, which again is one of the things we're trying to provide to you at BK FastPass here, is a referral to a high quality attorney. But the government has changed their tune on this in the last few. I love to beat up on the government, but let's be fair. In the last couple years, things have gotten a little bit liberal with this determination. The government has created the streamlined process to where you can potentially get out of your student loans in bankruptcy, and it's not this full-on lawsuit that it used to be. And what that means is people like me, bankruptcy attorneys, are now able, for much cheaper, to kind of test it out. And they call this, it's an attestation form. It's a streamlined way to determine whether the government agrees that the student loan should go away or not. So if you have a bunch of student loans and you have a kind of a unique situation, typically, age, you're elderly, you got medical situations, or you got so much debt and really low household income and you didn't get your degree, something like that going on, you might have the capacity to try to get rid of your student loans. But you got to jump through these extra hoops. The presumption is they will not go away. We talked about assets and that sort of stuff. Look, the vast majority of bankruptcies, and this is an important thing to think about here, the vast majority of these things are no asset cases. And what does that mean? Look, a no asset case is simply, it means there's nothing that the trustee can take, right? They can't liquidate this, that, the other, anything like that. And again, the vast majority of these things are no assets because it's either protected or of inconsequential value. So we talked a little bit about the Chapter 7 trustee, that sort of stuff. At the end of the day, the trustee is the person in charge with administering your bankruptcy estate. They do conduct the meeting of creditors that everyone has to go through. So let's kind of start at the beginning point. First and foremost, you got to find a good attorney in your jurisdiction. If you don't know someone, let us know. We can help you do that. Talk to that attorney. You might want to do some research. If you got student loans, hey, do you do adversary work? Do you do these sort of things? If it's determined that you're eligible for Chapter 7, there's a bunch of paperwork you're going to need to get to that attorney. Obviously, there's going to be some fees, and those can be all over the map. Once your case gets filed, that's when that protection takes place. You're protected from your creditors at that point. No lawsuits, foreclosures, repos can occur. Now, it's important to remember that the protection doesn't last that long. So if you've got, a repo on a car you want to keep, if you got a foreclosure going on in a house that, you're obviously hoping to save, you should be talking about Chapter 13, because you can actually check that box with that easier in a 13 than in a 7. Because as soon as you come out of bankruptcy, boom, you're behind on your stuff again. So you file. A month later, you have what's called a meeting of creditors. Your attorney will be there with you. Look, they call it a meeting of creditors. That's the section of the bankruptcy code, section 341. 95% of the time, no creditors show. It's you, your attorney, it's the bankruptcy trustee. The bankruptcy trustee is going to ask you a bunch of questions. In a lot of jurisdictions right now, it's on Zoom, which is amazing. You don't have to go downtown to the bankruptcy court, go through federal security and all that mess. So the trustee is required to ask a bunch of questions. On average, we're talking a 5 to 10 minute examinations. Did you list all your assets? Did you list all your debts? They're going to ask you how you valued certain things. Tax returns are the most common asset that people lose in a Chapter 7. I'm shooting this video, fall of 2025. Basically, we're 75% of the way through 2025 right now. If I file my bankruptcy today, and I get a large refund for 2025, the bankruptcy trustee says, hey, look, you had an overpayment to the government owed to you on the day your case was filed. You filed 75% of the way through the year. I'm going to want you to turn over to the bankruptcy trustee, the estate, 75% of that tax refund. It's a one-time deal. It only comes up for people typically filing late in the year or early in the year before they get and spend down their tax refund. Talk to your attorney about that one, because that's the most common asset that does get liquidated. But look, you file, you do your song and dance with the bankruptcy trustee about a month later. After that meeting of creditors, there's a 60-day window. Right? No news is good news during that 60-day window. That's when you're going to want to do your second counseling classes. There's all these stupid classes you got to take. They're on the internet. It's not a big deal, but you're basically waiting to see if anyone's going to object to your discharge. Well, who would object? Individual creditors can object to their debt being discharged in bankruptcy. Now, they got to have a reason. They can't just say, hey, this is bullshit. I don't want to get wiped out. Fraud is the most common loose category that they can claim an exception to discharge. So what does that look like? Like if I cash advanced $10,000 in October and filed bankruptcy in September or August into September, you get what I'm saying? Like a month or ballpark, even a little bit longer, the creditor's going to come along and say, hey, wait a second. You took a bunch of money out, you never paid us, and then you went bankrupt pretty quickly. You knew you were going bankrupt at the time you borrowed that money from us. That's fraud. That debt should not go away. Right? It's a fair argument, right? From the point things unravel and you're really exploring bankruptcy, you should not be using the cards or putting any more money on credit at that point. The judges love to say this, right? Bankruptcy is designed to provide relief to the honest but unfortunate debtor. That goes all the way back to the beginning of the bankruptcy system. And if at any time you start to look like a scumbag in the bankruptcy system, things can unravel for you. So you don't want to push this thing too far. And 99% of people never do this. But every now and then there's some dipshit who's like, well, I'm going to rack up all my shit and turn around and file bankruptcy the next day. It ain't going to work. Okay, it's going to cause a bunch of issues. The other thing that can happen, and there's a lot of things, but these are the big ones, is the government can come along and say, hey, we think you should be in Chapter 13. Right? Now, if you're below median, it's very unlikely to happen. If you're above median, you still can get through Chapter 7. You're going to need a good lawyer like this guy. But it still can happen within reason. But you got to typically be close, and we got to be able to bury you on some other expenses. But if you're above median and you're trying to do a 7, and the government kind of looks at your budget and says, wait a second, we think you could tighten, the strings here a little bit, go out to eat less, whatever. If the government watchdog of the bankruptcy system, which is called the U.S. Trustee's Office, which is a branch of the Justice Department, so we're talking about, federal lawyers here, they can try to dismiss your Chapter 7. They can file what's called a motion to dismiss your case. They basically say, hey, it would be an abuse of the bankruptcy system to provide this debtor a discharge in Chapter 7. We think they need to be over in Chapter 13. And at that point, you got to have a hard conversation with your attorney. And you can fight it. I've done it. I've beat them. To be fair, I fought it and lost too. It happens. Nobody's perfect. Or you just convert to 13 and kind of go from there. So those are strategic decisions that you have to have with your own attorney. But that's, generally speaking, that's the process, right? Ballpark, we're looking for our discharge about 4 months after the case gets filed. Now, that doesn't close the case because you might still have to cooperate with the bankruptcy trustee to turn some assets over. Maybe it's part of your tax refund. Maybe you had a boat, right? Maybe there are some things that the trustee is going to be like, hey, look, we think we can recover some money here. And sometimes it doesn't even involve them coming after you. If you made a large payment to a relatively close to your bankruptcy filing, that's what's called a preference. And the insider preference can be recovered by the bankruptcy trustee. So that's a problem there as well. So, okay, you get your discharge. Knock on wood, man. I got my discharge. Great. All your debt is no longer reporting as, behind, default. It now says discharge in bankruptcy. And your credit is starting to repair quickly. A year or two out of bankruptcy, typically the score is better than it was before you went bankrupt. Now, everyone's situation can be unique, and that algorithm is confusing, but depending on how far you were behind on your bills to when you filed your case and all that sort of stuff. The point is, you wipe out a shit ton of debt, and your credit repairs itself very, very quickly. Now, that bankruptcy is going to be on your credit report for 10 years, which does sound like a long time. Practically speaking, we find it affects people negatively for about 2 or 3. So, again, filing bankruptcy can be a very strategic business decision that families make that actually allow them to move forward and succeed in life way quicker than if they just keep their head in the sand slogging away at credit card minimums month after month after month. So myths that are out there, you'll never get credit again. Pfft, bullshit. Here's the funny thing about the world, right? So the very same creditors, the people that you're going to wipe out in your bankruptcy, like they're going to send you pre-approved credit cards again. Not too long after the bankruptcy discharge. It's insanity. And this is when I remind people, I say, look, you probably paid the minimums for so long. You paid those motherfuckers, right? Like, you discharged the debt that you owed Wells Fargo. I don't know those guys 20 grand anymore. I wiped it out. Good for me. But if you went back in time and calculated how much money you actually paid them back, I bet you paid them more than you borrowed anyway. So think about that think how powerful this predatory interest rate is that they can charge, right? You wiped out your debt to them in bankruptcy and they still made money off you. Right? Come on. Right? They love it. They love it. And they're gonna try to get you on that debt roller coaster again relatively quickly after your bankruptcy. And now you can't do another 7 for 8 years. They love you. They love you. Car dealers, oh my gosh, you get slammed by every car dealer around as soon as your bankruptcy gets filed because they know you've wiped out your debt and you'll now be able to afford a new car payment and they can charge you that beautiful, unbelievably high interest that they love so much. Look, not everybody's going to know that you went bankrupt. Look, the U.S. federal court system operates on an open record system. If someone wants to find out, they can find out that you went bankrupt. Nobody cares. Don't tell anyone. I mean, look, I went bankrupt. I mean, I use it as a marketing campaign more than anything, but you don't have to tell people. And the truth is, most people aren't going to find out. The funny thing that I talk to clients, and you go to a party or whatever, and you talk to someone in the corner, and you're kind of like, hey, man, I just wipe my debt out, and then people go, oh yeah, I did that like 3 years ago. It's like this little thing that the people will just kind of talk about on the side. You'd be surprised if you want to start telling people how many people in your circle have actually done it. But it's not the sort of thing you post on your Instagram that says, woohoo, just went bankrupt. Well, maybe you do now. I see people on the TikTok doing it all the time. So hell, the world has changed, that's for sure. Bankruptcy. There was a real estate investor, I think his name is Sam Zell. I've stolen his quote a little bit here over my career. A lot of people think that bankruptcy is the end. And what I always try to get people to understand is that bankruptcy is actually the new beginning of your life. And I can't stress that enough. And so the beauty of the 7 is you get to start that new beginning really, really soon. And that's what I love about it, Chapter 7. And I filed a ton of 13, so I love 13 a lot too. Actually, I prefer the 13, but I never put someone to 13 unless they have to or it makes a damn good reason. And in the next episode, I'm going to talk a lot about Chapter 13. But the main point of this to understand is the first thing you should be looking at is Chapter 7 and finding out, am I eligible? And if I'm eligible, what would I potentially lose, if anything? And if you're eligible and you don't lose anything, it's likely 7 is where you want to go. Hey, have a great day. I look forward to seeing you on the next episode of Screw 'Em Don't Pay.